Okay, let's unpack this incredible stack of sources we have today.
Yeah.
When you hear about the historical giants of global law, especially within the Islamic tradition, the places that usually dominate the conversation are, well, they're the established powerhouse.
Right. Baghdad, Damascus, Cairo.
Exactly. Or maybe Cordoba in Al-Andalus.
Yeah.
The academic gravitational centers of the medieval world.
And they absolutely deserve all the recognition they get. But our sources today are really demanding that we look far south and far west to a center of scholarship that during the 14th through 16th centuries was, well, it was generating legal intellectual output that absolutely rivaled those giants.
We're talking about Timbuktu in Mali.
Timbuktu!
And Timbuktu, it often conjures up this almost mythical image, doesn't it? You think of ancient golden wealth and vast desert caravans. But the sources make it clear that the deepest treasure of the Songhai and Mali empires wasn't the gold and salt. It was knowledge, and specifically advanced legal thought.
And that right there is the foundation for the entire mission of this deep dive. We are tracing a single, extremely powerful idea across 5 centuries and multiple continents. That judicial independence is not a modern European invention born out of the Enlightenment. Not at all. It's a universal political necessity, and it's been proven everywhere from medieval West Africa to modern constitutional debates in Asia.
That's the core argument, and it's a pretty profound connection to make.
Right.
So we're linking the qadis, the expert judges of Timbuktu, to the contemporary Supreme Courts of India and Pakistan.
Exactly. It's an intellectual lineage that all hinges on one fundamental question.
Does the ruler decide what the law is, or does the law decide what the ruler can do?
That's it. And to set the scope here, we are focusing on Timbuktu when it was at its absolute zenith, largely under the Mali and then the Songhai empires. This was an era where Timbuktu was wealthy because it was a node of global trade, yes, but it retained that wealth because it was a global center of advanced legal reasoning, the quality of its scholarship, the sophistication of its courts. It was competitive with anything being produced globally at the time.
And it's that institutional strength that allowed its judiciary to become truly defiant.
Precisely.
I think many listeners, including myself, before really digging into these sources, underestimate the sheer scale of the intellectual operation in Timbuktu. I mean, we're not talking about some sleepy little outpost.
Not even close.
Let's start with just the volume of knowledge and people. The sources detail that at its peak, Timbuktu was home to roughly 25,000 students. 25,000.
Yeah.
That's a massive academic population for any civilization, let alone a city deep in the Sahelian region in the 15th century.
That number is so critical because it just fundamentally redefines the city. It wasn't merely a trading post where caravans paused. It is essentially a massive university city built around trade. And those 25,000 students, they required libraries, lectures, documentation, and most relevant for us, a sophisticated legal system to govern them and all the commerce they depended on.
And crucially, that system wasn't relying purely on oral tradition, which I think is a common misconception about pre-colonial African jurisprudence.
It's a huge misconception. Timbuktu was one of the earliest centers of legal documentation in Africa.
And that move from oral to written legal documentation is a huge leap, isn't it, for establishing the rule of law?
It's everything. I mean, written records mean precedent is established, it's reliable, and it's reviewable. These legal systems were built on hundreds of years of prior written rulings.
So they have this inherent authority.
An inherent authority and a longevity that transcends the lifespan of any single ruler. When a Qadi made a ruling, he wasn't just pulling it out of thin air.
No.
He was referencing a library of written legal consensus.
And that legal rigor was necessary because Timbuktu wasn't just locally important, it was a truly cosmopolitan hub.
Absolutely.
You have this massive flow of humanity.
Yeah.
The jurists, the scholars, the wealthy Malian and Songhai merchants, sure, but also people traveling down from North Africa, and even, indirectly, European traders seeking gold and exotic goods.
And everyone was interacting.
And where there is interaction, there is conflict. Always.
And that interaction is really the secret sauce for the sophistication of the Sankore University and its associated court system. It forced legal pluralism.
What do you mean by that?
Well, the Qadis were not presiding over a homogenous society, not by a long shot. They were handling an incredibly diverse caseload that required, legal dexterity and, frankly, a lot of intellectual humility.
So let's detail that pluralism. We're talking about Qadis handling cases involving Local Muslims operating under the dominant Maliki school of law, yes, but also.
Also cases involving the Jewish community that was present in Timbuktu and indigenous African communities who operated under their own long-standing customary law traditions.
Right, traditions that predated Islam in the region.
By centuries. And then you add in the merchants from across the Sahara and even traders from Europe who were arriving via the North African ports.
So a judge's job in Timbuktu was therefore incredibly complex.
Imagine it. A case comes before you, a dispute over a commercial contract. The Qadi might have to consider, first, the specifics of Maliki Islamic commercial law.
Okay.
Second, any local customary law relating to, say, land or inheritance if the contract involved local resources.
Right, which it often would.
And third, the international trade practices that would be relevant to the North African or maybe even the European merchant involved.
Wow. The necessity of managing that cross-section of global society, it forced the system to become inherently sophisticated.
It had to. The sources really emphasized that this environment fostered a pluralistic, sophisticated legal culture. It had to be impartial because if a judgment arbitrarily favored one group,
The whole system of trade, which Timbuktu relied on, would collapse.
it would completely collapse. It's the ultimate validation of the rule of law, really.
How so?
Well, when your legal system has to withstand the scrutiny of a scholar from Fez, or the contractual demands of a Venetian merchant, or the traditions of a powerful indigenous group, the system naturally evolves.
It has to prioritize merit and impartiality over political expediency.
Exactly. And this professional environment is what nurtured the institutional courage necessary for our central historical figure.
So Timbuktu's wealth wasn't just in material goods, it was in the intellectual capital generated by the necessity of managing, reconciling, and ultimately adjudicating disputes between all these diverse legal traditions under one umbrella of justice.
That's it. And that professionalism is precisely what led to the legend of the judge who successfully defied the emperor.
Okay, let's move to Section 2 and introduce the figure who stands as the living embodiment of judicial independence in West African history, Qadi Mahmud al-Akit.
Yes.
This is where the historical precedent for this idea of a basic structure is laid down centuries before anyone even used that term.
Qadi Mahmud al-Akit, who died around 1548, was not merely a good judge. He was a giant of the Maliki school of Islamic jurisprudence, which was the most pervasive legal tradition across North and West Africa.
But his legacy rests on his character.
It does. He was known far and wide for his strict independence, uncompromising justice, and principled opposition to unlawful royal orders.
So he wasn't just a jurist, he was an institutional bulwark. The sources paint him as the recognized protector of the oppressed, which sounds like something out of an epic poem.
It does, but the fact that he was revered for this suggests that this conflict between legal principle and raw political power was a constant theme, even in the powerful Songhai Empire.
And we have a concrete incident, the high point of his career, that really proves this characterization.
We do, and it involves arguably the most powerful ruler in West African history at that time, the Songhai Emperor Aski Muhammad.
This is a colossal figure, right? He expanded the Songhai Empire into a massive, thriving economic and cultural power.
Absolutely, a giant of his era.
So what was the conflict?
It was brutal and simple. Askia Muhammad, in an exercise of what looks like pure, arbitrary political power, decided to confiscate the property of a wealthy man.
For what reason?
The sources make it clear this was an unlawful seizure. Perhaps it was based on convenience or greed or just the idea that the emperor's will was the law.
Right. L'état, c'est moi. The state is me.
Exactly. In the context of the time, the emperor's word was often absolute, particularly in matters of siyasa, that's political governance and state administration.
So to challenge him was to challenge the foundation of the state itself.
A huge risk.
Yeah.
So when this confiscation order came before Qadi Mahmud al-Akit, the entire legal system basically held its breath.
I just want the listener to pause and imagine the gravity of this moment. You are a judge appointed by the state, facing a direct order from the head of state to validate an act of theft against the citizen.
The personal danger, the political pressure, it's immense.
Yet, al-Akit stood absolutely firm. His ruling is really the defining moment of this entire deep dive.
The Qadi's response wasn't a political negotiation. It was a declaration of fundamental law. And the quote is central to our understanding of the separation of powers in this era, he said. The Sultan has no right to seize property except by the law of Allah.
Wow. That single sentence just establishes such a clear boundary between the lawgiver and the law follower.
It does. It asserts the sovereignty of a transcendent legal source, whether you call it Sharia or natural law, or the constitution over the temporary political authority of the Sultan.
He's saying your power is limited. There's a law above you.
And the sources emphasize that the emperor was astonished. This wasn't some private rebuke. This was an open, public challenge to the absolute authority of the Songhai Empire delivered by a civilian judge.
That takes incredible courage, but also institutional backing, right?
It required the legal community's intellectual backing and the Qadi's own sheer personal courage.
What makes this story so powerful is not just the quote, but what happened next, the aftermath.
Yes. The legal system, embodied by Aliquid, successfully upheld the rule of law. The property was returned to its rightful owner.
And, crucially,
The Sultan apologized publicly. He submitted to the judgment of the court.
that submission is historical gold. It shows that the legal institution in Timbuktu had accumulated so much moral and intellectual weight that even the most powerful political figure in the region couldn't defy it without risking his own legitimacy.
Qadi Aliquid wasn't just a jurist. He was an institutional force of nature.
And this is where we can bridge the gap to modern times. We look at this act, a judge overruling an executive order from a king, and we recognize the functional equivalent of judicial review.
Exactly.
In the Western tradition, we usually trace this back to Chief Justice Marshall in Marbury v. Madison in the early 1800s in the U.S.
Right.
But here, in 16th century West Africa, we see the principle executed perfectly.
It wasn't called judicial review, and the mechanism was rooted in Maliki jurisprudence and the doctrine of Sharia supremacy rather than a written constitutional text. But the function is identical.
Explain that.
The court evaluated the validity of an executive act, the seizure order against a higher fundamental law, in this case the law of Allah, and declared the executive act null and void.
But hold on, isn't calling it judicial review a bit of an anachronism? How do we make sure we aren't just projecting modern Western codified concepts onto a traditional system like Maliki law?
That's a critical question, and I think the answer lies in understanding the inherent structural safeguards within Maliki jurisprudence, particularly in this region.
Okay.
Maliki law was highly responsive to the concept of public interest maslaha. It also made a very firm distinction between Sharia, the divine law which the Qadis administered,
And siyasa.
and siyasa, which was the political administration that the Sultan managed. This distinction provided the Qadis with the conceptual space to challenge the Sultan's political orders if they violated the foundational divine law that was entrusted to the jurists.
So the system wasn't designed to allow the Qadi to challenge the Sultan on, say, military strategy.
No, not at all.
But it absolutely empowered him to challenge the Sultan on matters of fundamental justice, like property rights.
Exactly. The judge wasn't relying on a political document. He was relying on a deep moral and legal consensus that held even the emperor accountable.
For law to be truly law,
Yeah.
there must be a transcendent standard, a constitution, a sacred text, a tradition, that the ruler himself is subject to.
And Timbuktu codified this functional separation centuries ago, creating an institutional precedent that limited political power. And that principle of legal resistance against absolute power is the bridge we can now use to jump into the modern constitutional battles of the 20th century.
That concept of the law having a soul, an essence that cannot be violated, that takes us directly to modern constitutionalism. We're moving from the Sahelian desert in the 16th century to the vast complexity of the Supreme Court of India in the 1970s.
A big jump.
A huge jump. And this is where we confront the landmark case that fundamentally redefined constitutional theory, not just in India, but globally. Kesvananda Prati v. State of Kerala in 1973.
This case is monumental. It's arguably the most consequential judicial decision in the history of the common law. And it arose from a really fundamental conflict.
Which was?
The post-independence Indian parliament claimed it had unlimited power to amend the constitution,
Okay.
while the judiciary feared that parliament could essentially use that power to dismantle India's core identity, its democracy, its secularism, its Republican nature.
And the political context here is crucial, isn't it? This wasn't some minor legal squabble.
Not at all. This was the era when Prime Minister Indira Gandhi was consolidating massive power. Parliament had already passed several amendments, the 24th and 25th Amendments, that aimed to explicitly limit judicial review and subordinate fundamental rights, especially property rights, to legislative convenience.
So the political branch was basically asserting that the will of the elected majority was absolute.
It was, and that's the precise moment where the judiciary had to draw its line in the sand, echoing Qadi Aliquid's defiance centuries earlier.
How do they do it?
The case was argued before a bench of 13 judges. the largest bench ever assembled by the Indian Supreme Court, and the tension was palpable. The question was disarmingly simple.
What was it?
Did Parliament's power under Article 368 to amend the Constitution include the power to destroy the Constitution?
And in a stunning and incredibly precarious decision, the Supreme Court ruled 7-6 by the narrowest of margins.
The absolute slimmest of margins.
Establishing what is now famous globally as the basic structure doctrine. The ruling was profound. Parliament may amend the Constitution, but cannot destroy its basic structure.
This doctrine represents the ultimate limitation on legislative power, even in a democracy. It says that democracy is not merely procedural.
It's not just about winning elections and passing laws.
No. It must also respect certain intrinsic, non-negotiable values that define the constitutional identity.
Let's elaborate on what the court defined as this basic structure, because it's not explicitly written in the Constitution, is it? The court essentially discovered it by interpreting the spirit of the document.
That's a good way to put it. They inferred it. And the key elements that the court has established over time include the supremacy of the Constitution itself, the republican and democratic form of government, the secular character of the state, the separation of powers between the executive, legislature, and judiciary, the rule of law, and, critically, judicial independence and the protection of fundamental rights.
So these are the identity markers, the things that give the Constitution its life and purpose.
Exactly. So if Parliament tried to amend the Constitution, to abolish free and fair elections, or to declare India a non-secular state, the Supreme Court could strike down that amendment.
Because it would demolish the basic structure.
Right. This doctrine prevents the legislature from achieving what some call constitutional dictatorship, even if they use perfectly legal procedures to do it.
It's a preemptive defense mechanism.
It is. The brilliance of the doctrine is that it recognizes that absolute power corrupts, whether that power is held by a monarch in Timbuktu or a democratically elected parliament in Delhi.
And we have to highlight the political drama that surrounded this. The ruling had immediate and deeply consequential fallout.
Oh, yes. The very day after the judgment, Prime Minister Gandhi dismissed 3 senior judges who had been part of the majority.
Unbelievable.
She appointed a junior judge, Justice A.N. Ray, as Chief Justice of India, clearly signaling executive displeasure and setting a very dangerous precedent for undermining judicial independence.
And that retaliatory move, known as the supersession, just shows how much was at stake.
The political establishment recognized that the court had essentially checked their ultimate power. And later, during the emergency from 1975 to 77, Parliament, under the 42nd Amendment, attempted to explicitly and legislatively abolish the basic structure doctrine and judicial review entirely.
But those attempts failed.
They failed because of the resilience of the doctrine and the bravery of the judges who created it, like Justice H.R. Khanna, who was that critical 7th vote. His judgment, which cost him the Chief Justice position, is a testament to the personal cost of judicial independence.
It connects directly back to Qadi al-Aqit, doesn't it? The cost of defiance.
Absolutely. Al-Aqit risked the Sultan's wrath. Justice Khanna risked and lost the highest judicial office in the land for his principle.
So now, let's do that detailed comparative analysis that the sources structure for us. The parallels between a 16th century Islamic judge and a 20th century secular court are just striking, despite the 400-year gap.
They really are. In Timbuktu, Qadi al-Aqit stood against the arbitrary executive powers of the Sultan, specifically when the Sultan unlawfully tried to confiscate property.
Okay, the executive.
In India, the Supreme Court stood against the potentially arbitrary legislative power of Parliament, limiting their power to amend the fundamental document itself.
So the judiciary versus the legislature.
Right. But both acts were about placing a legal limit on the supreme political authority of the day.
And in both instances, the judiciary was protecting fundamental rights. Al-Aqit protected a specific property right and the general principle of citizen rights against royal fiat.
And the Indian court protected a comprehensive set of fundamental rights: speech, equality, life, against a legislative attempt to override them permanently.
Philosophically, this seems to be the most important link: the transcendence of law.
I think so, too. In Timbuktu, the law above the ruler was framed through religious and traditional code sharia and fiqh. In modern India, the law above the government is framed through the codified constitutional text.
It's the same vertical hierarchy of authority.
Exactly. It demonstrates that this pursuit of limited government is not tied to any single religious or political system.
And what about the culture required to make this work?
That's a great point. Timbuktu was built on an independent jurist culture, where the prestige of the Qadi was often greater than the political power of the regional administrator.
And India's basic structure doctrine required an independent philosophical culture.
Yes. A willingness among judges to confront the elected political power directly, even if it meant risking retaliation.
So the ultimate result in both systems is the same. The ruler, be it a sultan or a parliament, was subjected to a higher law.
Both systems recognize that the Constitution, whether it's a written document or a body of respected traditional law, has an inviolable soul. And the moment that soul is breached, the structure of justice itself is compromised.
So the lesson here is profound. Great legal systems aren't established in times of peace. They're defined in these moments of high-stakes confrontation, when a powerful political actor tries to push the boundaries and the judiciary has to find the courage, the institutional structure, and the intellectual firepower to just say no. That concept of judicial defiance, of drawing a line when political power is pushing its hardest, that takes us to our second modern parallel in Section 4, Pakistan's Supreme Court judgment in the military court case of 2015.
Right.
And this adds a critical layer of complexity because the challenge to judicial power here involved not just political ambition, but national security in the face of an existential crisis.
The context is absolutely critical to understand this one. In late 2014, Pakistan suffered the devastating attack on the Army Public School in Peshawar.
A horrific event.
Horrific. Hundreds of children and teachers were killed by terrorists. And this created an immediate, desperate national consensus that the existing civilian justice system was too slow, too intimidated, and too easily compromised to deal with massive terrorism.
So the government responded with a constitutional measure.
It did. Parliament passed the 21st Amendment, and this amendment allowed for the establishment of military courts specifically for the trial of civilians accused of terrorism.
So it was circumventing the normal civilian judicial process.
Completely. The justification was clear. This was an emergency, it was necessary for public safety and the survival of the state.
And that created an immediate and profound constitutional crisis. The question before the Supreme Court was arguably even more sensitive than in Kesavananda Farhadi.
I would agree. The question was, can Parliament amend the Constitution in a way that fundamentally alters the nature of judicial power, carving out an entirely separate non-civilian judicial system for a specific class of citizens, even under the guise of national security?
So you're balancing the doctrine of necessity against the principles of democracy and the separation of powers.
Exactly.
This smells like a direct assault on the rule of law, similar to what the Indian court prevented. But here, the crisis was immediate and the stakes were measured in human lives.
It was an incredibly fraught decision. The sources note that the final judgment was split, which really reflects the profound difficulty in reconciling democratic principles with counterterrorism demands.
So what was the outcome?
The majority ultimately upheld the 21st Amendment. They deemed it a necessary temporary measure under those specific extreme circumstances.
But the key takeaway, and the part that directly links back to Timbuktu and Delhi, isn't the final outcome on the amendment itself, is it?
No, it's not. It's the powerful assertion of judicial authority the court made in the process of reviewing the amendment.
What do you mean?
Even while conceding the necessity of the measure, the Supreme Court unequivocally asserted its continued authority to review constitutional amendments in exceptional cases. They emphatically reaffirmed judicial independence as an essential, unalterable feature of Pakistan's constitutional identity.
So it was a clear judicial flexing.
A huge one. They were reminding the executive and the legislature that while they may act in a crisis, the court remains the ultimate arbiter of constitutional integrity.
And here we find the clearest conceptual echo of the basic structure doctrine, this idea that the structure of the Constitution must be preserved despite political pressure.
And we have a powerful quote from one of the dissenting or concurring judges, Justice Jawad S. Khawaja, who explicitly stated, "Judicial independence is part of the Constitution's structure."
Wow.
He was channeling the ghost of Kesavananda Farhadi and, unknowingly, the spirit of Qadi Alakat. He was asserting that the power to judge is inherent in the constitutional arrangement, and it cannot be removed or fully subjugated to political or military authority.
So it's the principle of the inviolable soul of the Constitution reasserting itself. Even when the majority felt the emergency justified the measure, they simultaneously made sure they retained the authority to challenge future, perhaps less justifiable, attempts to permanently undermine judicial power.
Exactly. They drew a temporal line, suggesting that this arrangement was permissible only for a specific, limited duration.
And it's important to note the historical significance in the Pakistani context, right? The courts there had historically struggled with the doctrine of necessity.
They had. It was often used to legitimize military coups or extra-constitutional acts. So by using language similar to the basic structure doctrine, the Supreme Court was symbolically pushing back against its own history of submission. They were confirming that judicial independence was now understood as a structural safeguard, not a political convenience.
Okay, let's consolidate this comparative analysis because this is the knowledge synthesis moment for the learner.
Yeah.
We have three distinct eras, three very different legal and political forms of government, yet they're all grappling with the same threat to justice.
First, medieval Timbuktu. The court resisted arbitrary, oppressive royal interference. It was the Qadi versus the king, a singular, courageous challenge to the executive acting above the law.
Second, India in 1973. The court resisted parliamentary supremacy. This was the judiciary versus a potentially overreaching legislature, asserting that the rule of law flows from the Constitution itself, not from the temporary majority party's mandate.
And third, Pakistan in 2015. The court balanced national security imperatives against judicial independence. This involved balancing the urgent demands of the military and the executive in a crisis against the sanctity of the judicial system and the fundamental right to a civilian trial.
The shared message is just undeniable and timeless. Judicial independence must survive even when the political stakes are highest.
Yes. Whether the threat is an arbitrary king, an overconfident parliament, or the profound pressures of an existential national security emergency, the legal system has to have the institutional spine to stand apart from the temporary, expedient demands of the ruling power.
And this struggle isn't about preserving the prestige of judges.
No, it's about preserving the state's covenant with its citizens. Because the moment judges cannot defy power, citizens lose their final effective recourse when that power becomes tyrannical or oppressive.
This brings us to Section 5, the grand synthesis, where we tie 5 centuries of legal history into one core unifying principle. We have seen a 16th century Maliki jurist, a 20th century secular democracy, and a 21st century state facing radical terrorism, all arriving at the same structural conclusion about the limitations of power.
And the combined doctrine, the real aha moment we can derive from Timbuktu, India, and Pakistan, is powerful in its simplicity and its universal applicability.
Which is,
Power must never be absolute, not for kings, not for parliaments, not for armies.
that is a constitutional principle that transcends legal systems, political structures, and religious mandates.
It is. Whether your legal authority derives from divine command, a written constitutional text, or a democratic mandate, the mechanism of judicial review, the institutional ability of a court to say no, is the ultimate structural safeguard against the arbitrary exercise of authority.
It is the ultimate expression of moving the law above political authority.
In Timbuktu, the Qadi placed the traditional and religious law above the royal fiat. In India, the Supreme Court placed the written constitutional text above the legislative majority.
And in Pakistan, the court placed the essential structural principle of justice above the counter-terror arrangements demanded by the crisis.
And this leads us directly to the ratio decidendi, the core takeaway provided by the sources, which summarizes everything we've discussed with stunning clarity.
And what's that conclusion?
Judicial independence is a universal necessity from medieval Timbuktu to the modern Supreme Court. Where judges can defy power, justice survives. Where they cannot, nations fall.
That phrase, where judges can defy power, that's the metric, isn't it, for the health and success of any civilization.
It really is. Qadi Aliquid's willingness to openly defy Askia Muhammad was not just an anecdote. It was a foundational moment in West African legal history. Had he failed, Askia Muhammad would have cemented a tradition of arbitrary rule.
And Timbuktu's reputation as a stable, predictable legal center would have crumbled.
Which would have ultimately harmed its trade and its intellectual standing.
And we can trace the tangible impact of this judicial defiance across all 3 civilizations. Timbuktu's institutional courage in holding its rulers accountable produced one of Africa's strongest, most revered legal and scholarly traditions, which endured for centuries.
India's basic structure doctrine fundamentally shaped all subsequent constitutional amendments, creating an almost impenetrable legal shield around its core democratic principles. It ensured that, regardless of which political party came to power, the foundation of the democratic state, including the courts themselves, remained sacrosanct.
And Pakistan's 2015 ruling, even in its split complexity, preserved the necessary judicial balance during a moment of profound national crisis. The court maintained the authority to review and regulate exceptional measures, preventing the establishment of a permanent precedent that would subordinate the civilian judiciary to the military in perpetuity.
And the timeless result is that constitutions succeed when courts are fearless. This fearlessness isn't just a function of individual personal courage, though that is essential.
Right.
It's about the institutional strength built over generations, the same strength that allowed a 16th century scholar relying on traditional law to stand up to an emperor, and a modern court relying on a written text to stand up to a supermajority legislature.
The final moral lesson we take away from this synthesis is this concept of dual protection.
Yes. A judge who uses his independence to protect the weak citizen strengthens the nation.
And perhaps more crucially, a nation that structurally protects its judges strengthens civilization itself. That protection has to flow both ways.
It has to. When a nation allows its judges to be intimidated, whether by violence, political pressure, or internal corruption, it willingly forfeits its claim to the rule of law.
Before we conclude, we should acknowledge the source of this remarkable comparative research.
We must. This material was researched and authored by Mr. Zahir Ahmad Mir, a constitutional and corporate lawyer, and the author of over 55 books. His work spans law, Islam, Pakistan, AI, and global thought. And his ability to connect 16th century Maliki law to the complexities of 21st century constitutional jurisprudence is, I think, a testament to the universal nature of the law.
We've traveled 5 centuries and thousands of miles today, covering the forgotten legal history of Timbuktu, the incredible bravery of Qadi Mahmud al-Akut, and the continuation of that exact same fight for judicial limits in modern constitutional law in India and Pakistan. This deep dive has shown us that the principles of limited government and judicial review are profoundly global, ancient, and necessary.
What stands out time and again is the endurance of the underlying principle. The specific language of the law, be it the Maliki school, the unwritten constitution of an empire, or a codified document, is far less important than the institutional will of the jurist to protect that fundamental law from political ambition and immediate necessity.
So what does this all mean for you, the learner, in your own modern context? It means the foundations of justice are far older and more global than we often realize. But we want to leave you with one final provocative thought that builds directly on this source material and applies this history to our present day.
Qadi Mahmud al-Akut was resisting the absolute power of the Songhai Emperor Askia Muhammad, which was concentrated executive power. The Indian Supreme Court resisted the legislative supremacy of Parliament. Both were traditional, recognizable forms of state power.
Today, however, power is becoming increasingly non-traditional, non-state, and decentralized. So we have to ask, what modern institutions, currently taken for granted, represent today's equivalent of Askia Muhammad's challenge?
Is the unchecked, functionally limitless power of global corporations over speech and commerce the new executive fiat? Is the use of surveillance technology to monitor and control citizens outside of traditional judicial supervision the new arbitrary confiscation?
Or is the growing dominance of unelected administrative state agencies, the so-called regulatory deep state, the new overreaching parliament?
And how might judges, faced with these new, subtle, and non-traditional forms of power, need to invoke basic structure principles? The idea that the spirit of freedom and justice, fairness, and due process must not be violated to resist them.
The fight for judicial independence, as proven from Timbuktu to Islamabad, is never truly over. It simply changes its antagonist.
A critical thought for anyone who cares about how law shapes civilization.
A truly fantastic deep dive. Thank you for sharing your sources with us and joining this journey through the timeless history of legal defiance.